except for issues 10 and 11, which we're going to take up shortly when we get to the Office of Inspector General. Is there objection to Representative Price's motion? Hearing no objection, the report is adopted. Now, is that it? That's it on that piece. Members, that concludes our work on the Health and Human Services Commission. Whoa. We are setting a bold new course for these programs. Senator Schwartner, you've got a lot of good challenges ahead. I think that we are on a great course to serve our most vulnerable citizens. I'm hopeful that these structural changes will lead to better, more effective services and overall a more efficient system, and that is the job of this commission. So thank you all for your great work on that. So we're going to take up issues 10 and 11, which relate to the Office of Inspector General. There are two modifications, and Senator Hinojosa moves that we sever issues 10.11 and 11.1. Is there objection? Hearing none, those recommendations are severed. Now Senator Hinojosa moves we adopt issue 10 and 11 minus the items we just severed. Is there objection to that motion? Hearing none, the issues are adopted. Whew. Now, members, if you'll remember, at the last hearing, I appointed a work group to review the sunset recommendations for the Office of the Inspector General. At that time, I announced a work group, and Senator Hinojosa chaired that work group. I know how much time you spent in a very condensed time frame, and am most grateful to everybody who worked on ironing things out. And Senator Hinojosa, I'll recognize you right now to talk to us about that modification.
Thank you, Madam Chair. Actually, we had a great working group, including Senator Huffman, who was actively participating in the process and with the work group, as she has done a lot of work with the OIG last session. And we made some recommendations and modifications, and one dealing with a modification to issue 10 with the OIG management. And we would modify recommendation 10.11 by adding a management action to direct OIG upon finding state employee fraud, including OIG employees, to promptly notify any affected or harmed providers. And I think that's only fair in the process. If you find an employee for the OIG, as has happened in the past, that does damage to the provider, that the provider ought to be notified immediately. Then we have a modification to issue 11. And as you well know, the credible allegations of fraud holes have been somewhat controversial. We try to provide better direction, much more objective criteria to be able to expedite the process itself. Now, many cases are taken on the average 3 years, some as long as 9-10 years, and we're trying to make those adjustments. So some of the modifications that are recommended by the work group to issue 11, it would require SOA to hold a CAF hold appeal hearing within 45 days of the request for a hearing, rather than 30 days as recommended by the sunset staff. We will also require the OIG to provide a detailed summary of all its evidence as to the credible allegations of fraud, together with a notice of payment hold, along with a timeline detailing the provider's appeal rights and next steps in the appeal process. Right now, they do provide information and some detail to a provider, but we wanted to be more specific and detailed so that we won't waste any time and the provider understands why the provider is being accused of fraud. We also have a modification to 11.3 management action. On number 3, we direct the OIG to adopt updated rules by March 1st, 2016 to conform with the changes in statute limiting placement of payment holds to a credible allegation of fraud at the request of the Attorney General's office or to compel the production of records.
Okay. Question?
And that's
You have,
and then modification number 4, some statutory changes require the Office of the OIG to pay costs associated with overpayment hearings at SOA, excluding provider attorney's fees, just as sunset staff proposed for credible allegations of fraud hearings in recommendation 11.4. Number 5, amend the statutory definition of fraud in Government Code Section 531.1011, 4 in parentheses, to clarify that the term does not include unintentional technical, clerical, or administrative errors. The amended definition would read as follows. Fraud means an intentional deception or misrepresentation made by a person with the knowledge that the deception could result in some unauthorized benefit to that person or some other person, but does not include unintentional technical, clerical, or administrative errors. And there's been a problem in many times when they make the allegation of fraud. It also includes clerical mistakes, program mistakes. Instead of dealing with a real issue, there's fraud being committed by the provider. It also removes the statutory right for providers to have 2 informal resolution meetings before overpayment hearings. Providers will maintain a right to 1 informal resolution meeting at the provider's request. Specify that the informal resolution meeting will run concurrently with the overpayment process and will not delay the timing of the overpayment hearing. And the reason that's important is that they were concerned about the request for an informal meeting to be used as a tool to be able to delay and prolong the hearing process to determine whether or not there was a hold actually taking place or whether the hold is proper or not with the provider. And finally, modification number 7, have the CAF payment hold should not replace the providers for services that have received prior authorization by the Commission or its contractors as medically necessary unless additional evidence is presented that the provider has materially misrepresented documentation for the proposed medical or health care services. OIG will retain the ability to pursue all overpayment regardless of whether a claim received a prior authorization. Madam Chair, those are the recommendations.
good work, good work. And you got exactly to what we want, and that is going after fraud and not spending our time on things that are not fraud.
One of the things we're trying to do is expedite the process so that within 45 days of the hearing, each side will be allotted 4 hours of testimony to find out if there is actually probable cause or any substance to the credible allegation of fraud. And the judge can determine whether there is or there's not. We think this will expedite the process and then have a hearing on the actual hold within 180 days. So that there's a determination and not expose the state to financial risk.
Okay, yeah, good job, and I appreciate, I know how much time your committee spent on this, and Senator Huffman, who isn't even on the committee, I greatly appreciate your work on this. Any questions on this particular modification? Actually, 2. All right, so we are addressing modification 9 on page 150M and 1 on 160A. Senator Hinojosa recommends the adoption of those modifications. Is there objection to that, the adoption of those modifications? Hearing none, those modifications are adopted. Senator, thank you.
Thank you.
And thank the work group. We do have one additional modification on this issue. Representative Raymond, Chair recognizes you on that modification.
Thank you, Madam Chair. Members, to remind you, this particular modification deals only with overpayment hearings only, not CAFs.
And excuse me, Representative, but you have a modification to your modification.
Yes.
I suggest you talk about both of them so that everybody realizes where we're ultimately getting to.
Well, let me, again, one of the issues that came up, as you all will recall, during the testimony and the hearing was this the problems at OIG bleeding over into areas like pharmacies. And so what we've done with this and working with the Sunset staff, and I think all of your staff was briefed on this, and I think most of you already were as well, but let me read this. This was typed out for us, written with the help of Ken and his staff, so we did it correctly. It says, Pharmacy Audit Appeals Process. Modification to Issue 11. A modification of issue, instead of modification 13 to Issue 11 on page 160I of the decision material, substitute the following as a statutory change. And it would be, provide that all pharmacies audited by OIG or a federal Medicaid contractor and not accused of Medicaid fraud be afforded a right to an informal hearing, but with the following changes to strengthen the process. Informal hearings would be held at the HHSC Appeals Division instead of OIG to promote independence in the appeals process. This modification would remove OIG from being on the decision-making panel for its own audit hearings, instead having more objective HHSC appeals staff making judgments on audit results. Staff from HHSC Vendor Drug Program would continue to sit on the decision-making panel to provide expertise on Medicaid pharmacy rules. Require OIG to provide detailed information to audited pharmacies to increase transparency related to the methods used to determine the overpayment and any extrapolated amounts. This modification would also require the agency to amend its rules as needed to comply with these changes no later than March 1st, 2016. Again, members, you'll recall some of the examples we had where the audits that were done, we're looking at pharmacies that all of a sudden we're being looking at millions of dollars or hundreds of thousands. It just, this allows them to appeal, but go to HHSC to let them do the appeal so that it is more neutral. Although I'm sure, at the end of the day, HHSC's charge is to look out for some of the things that OIG is looking out for. But given the history of the OIG and the problems we've been having there, we think this is another good modification.
Questions, Representative Hinojosa?
I know, Madam Chair, we discussed this issue in the work group, and it was somewhat cumbersome in trying to provide the same due process we provide other providers. But this is a good compromise to try to give them at least some review by another objective agency other than the OIG.
Yeah.
Thank you, Mr. Chairman. Thank you for your work.
Yeah. How many audits does OIG do? Do we know? Total.
There's a few thousand.
Wow.
A year.
They have the authority to audit anyone in the system, and so even what they decide to audit, the subject of what could be audited is really dependent on the OIG's determination of risk.
Madam Chair, I'd like to move that they can't audit us.
You're not recognized for that motion. Any other questions of Representative Raymond? Good job. Good. Is there objection to the adoption of the modification to the modification that Representative Raymond just described? Hearing no objection, the modification's adopted. Is there objection to the adoption of the modification itself? Hearing none, Representative Raymond's modification is adopted.
Thank you, Madam Chair, members.
Thank you. So now Senator Hinojosa moves that we adopt issue 10 and issue 11 as modified. Is there objection? Hearing none, issues 10 and 11 as modified are adopted.